It's really good to be here. I was particularly intrigued by the name of this conference because it's something I've thought about a lot. So today I'm going to just give a kind of set of very tentative thoughts, which are, in no way a sort of fully worked out academic paper, but there's some of the reflections that I have, partly based on my academic research, but substantially based on my sort of personal experience working for a regulator in the UK. So this conference, the title is very intriguing: Governance of and by Algorithms. So I really was interested when I saw the title of this conference, because I think it raises lots of interesting questions about this of and by construction. So if we start off by thinking about governance by algorithm. So governance here we could interpret in a broad sense as coordination between actors on the basis of rules. That's Katzenbach and Ulbricht's definition. Or we could think about algorithmic regulation, similarly broadly defined by Karen Young as intentional attempts to manage risk or alter behavior in order to achieve some pre-specified goal. These definitions encompass quite a wide range of different phenomena, and they've been used to describe a sort of general ubiquitous mode of emergent governance that's taking place at a global level, a kind of what we might think of as an algorithmic leviathan. So the algorithms are setting up and enforcing the rules that we all have to live by. So there's kind of this sense of a sort of Hobbesian leviathan. By contrast, the notion of governance of algorithms is perhaps what is the current discourse is mostly focused on in the legal sphere. So we're talking here about regulation of mostly large firms or government actors who are using algorithms to do the stuff that they do, and how we can, as a society, as stakeholders, as a demos, but specifically also as regulators, how can we govern these algorithms, and whether these algorithms are based on AI, machine learning, or just good old-fashioned rule-based systems, they're having a greater impact on our economies, on our social and private lives. So how can we think about the application of things like fundamental rights, like equality, privacy, data protection, to the use of AI by governments and private sector actors? So as I said, I'm going to be drawing from my experience working at the Information Commissioner's Office. So this is the UK's data protection regulator. So the ICO has historically had quite a strong focus on AI, big data and machine learning. While I was there, one of the things I was working on was a framework for regulating artificial intelligence. So this was both a methodology for the ICO to assess data protection compliance with AI systems, but also supporting people within the regulator to have the right knowledge, capabilities, and so on to support the work of the ICO, and as well as providing external guidance for organizations on how to address data protection risks in AI systems. So while I was working at the ICO, various other regulators in the UK, such as Ofcom, the communications regulator, the Financial Conduct Authority, the Consumer and Markets Authority, and the Bank of England, were all also looking into how to deal with the new challenges that were being raised by the use of algorithms and AI in the sectors that they regulate. This sort of culminated in the newly set up Digital Regulation Cooperation Forum. And within that, there's an AI and data science regulatory capacity working group whose role is to coordinate between different regulators to combine knowledge and skills and even resources to undertake the challenges that they face when it comes to regulating AI. So this kind of raised a few distinct questions for regulators. So first of all, what do regulators expect from regulatees? So regulated entities who are using AI, what do regulators expect from them? And so obviously that's going to differ depending on the different to substantive regulatory compliance questions, which will differ between different regulators. There are also cross-cutting principles, so things like explainability, transparency, robustness, principles that different regulators could agree on, even if the sort of details of their regulatory remit differ. Second question is what skills, resources, and tools do regulators need to regulate algorithms? And finally, how might regulators in fact use algorithms themselves in their own work? So question one is a big topic. It's something that there's a lot of literature on. Other legal scholars, some of them whom are here today, have plenty of interesting things to say about this, and I have made my own small contribution to this space as well. Question two is perhaps one that's received a bit less attention, and question three similarly. And so I'd like to focus on questions 2 and 3 today. So we have this kind of standard model of regulation where there's a regulator, there are several regulated entities, each of whom develop their own algorithms for deployment in their own contexts. And maybe the regulator issues some codes or guidance or rules that these regulatees can read and work out how they apply to the use of AI in their own context. And maybe they produce a set of internal policies that enable them to implement the regulator's guidance internally. And so this model, it seems to kind of capture one of the dominant forms, I suppose, of regulating AI. And when it works well, it could work very well. We have a regulator that's well resourced, a limited number of regulatees, and hopefully the ability to take the codes or guidance or rules and implement them themselves. So it sounds simple, but unfortunately, my friends, das ist gar nicht so einfach. It's not so simple. There are a number of problems that arise in this model, which I'm going to kind of go through. So the first problem is that in many cases, the actual implementation details of the algorithms are hidden behind the policies and the principles that the regulatees create. So what you're doing as a regulator is not really interacting with the people who are making the decisions on the ground, the engineers, the product managers who are deciding how to implement the algorithms in practice. You're dealing with the compliance people, the lawyers, who even when participating in good faith are less close to the details. And so that's one of the issues. Firms being reluctant to bring their technologists into the conversation alongside their legal and compliance teams with the regulator. Another problem is that these algorithmic systems that the regulatees are using typically are not developed in-house. They're actually outsourced to global technology firms who may not be directly within the regulator's purview. So the regulator is interfacing with the regulatees and getting lots of detail about their policies and principles, but the actual algorithms that the regulatees are using are outsourced and are out of sight of the regulator. Final problem, related problem, is that regulators are facing an unequal playing field when it comes to the entities that they regulate. There's an inequality of arms in terms of expertise and resources between the regulators and the more powerful regulatees whose activity is most in need of regulation. So we have a kind of David and Goliath situation. The plucky David, the regulator, is attempting to rein in the power of these regulatees, and all he has is a puny slingshot and a loincloth covering his scrawny body, offering no protection in case of the battles to come with these powerful regulated entities. And this inequality is kind of present at different levels. So the simplest one is budget. Even the most well-resourced regulators may lack the budget to hire enough staff to pay the legal costs of appeals. So they get tied up in enforcement appeals, which burn substantial holes in their operating budgets. You can compare this to the big tech firms, the big banks who have legal budgets in the billions and who spend millions on lobbying every year. Another inequality in the context of regulating algorithms particularly is in the level of technical expertise on the regulator side. So a study by the browser vendor Brave last year, they studied the data protection authorities of EU member states, and they found that 22 out of 28 of them had fewer than 10 technologists working for them. And nearly a third of them were actually working for the German Länder. So you guys are doing pretty good, but the rest of Europe's lagging behind. Meanwhile, the firms that are being regulated have armies of technologists who understand how the algorithms work, and the regulator is left having to take their word for it a lot of the time. And so this creates a real problem for the regulators when they're trying to do things like assess necessity and proportionality. So their lawyers understand well how these balancing tests work. So that can often mean that they're well equipped to answer questions about proportionality, but they're not always well equipped to answer questions about necessity. So whether the same purpose could be achieved in a different way, a different algorithm could be designed, or a different system other than an algorithm could be used, which interferes less with fundamental rights. That's in part a technical question. And so when the optimization process is algorithmic, how do you make an assessment about that algorithm? And this requires people with technology expertise to unpack the complex ways that algorithms work and their consequences for affected individuals. This doesn't mean that regulators need to hire superstar AI big names and academics or engineers. What they need is people who can cut through the hype that is often surrounding these technologies, people who can ask simple questions, but crucial questions, and can sniff out when the answers are attempts at technical obfuscation or whether they're genuine challenges that the regulatee faces. So this came up in context of trying to understand the error rates of an ML system. Firms were very happy to send lawyers and compliance people and government affairs people